Good morning, good afternoon, and good evening to everybody who has joined us today. And welcome to our webinar on video conference oppositions and appeals before the European Patent Office. It's been a year of rapid change as the EPO has had to adapt to operating in a virtual world. And in this session, we'll talk to you about how this has impacted oral proceedings over the last year. And then we'll finish with the discussion on the recent referral to the Enlarged Board of Appeal on the legality of virtual oral proceedings. Speaking to you today are Steve Howe and Chris Smith from our Software and Electronics Group. Steve and Chris are both based in our London office, and more importantly for today's session, they represented the patentee at the appeal that has led to this Enlarged Board referral. Also speaking to you will be Paul Loustalan, who is from our engineering group and is based in London. Paul's been a regular at video conference hearings over the last year, as well as having attended oral proceedings before the examining division for many, many years. And so I'm very happy that he's able to share his experiences with you today. And my name is Robert Ellis. I'm in Reddie Grose's Life Sciences team, and I'm based in our Munich office, and I'll be chairing today's webinar. Just a few housekeeping tips. We hope to have 10 to 15 minutes at the end of this session for questions. There have been a few developments in the last, 48 hours on this case, but we still hope to keep within the time limit so you can ask questions. Please either put these in the comments box, or at the end, we will open up the mics for questions in person. We will be recording the audio of this session, but we will turn it off for any questions. So you will remain anonymous in any recording. Just a little bit about Reddie Grose's opposition team, for those of you who don't already know us. We represent clients in opposition proceedings across all technical areas. We are very proud of our track record over the past 10 years. Before both the opposition divisions and the boards of appeal. And we certainly look forward to being able to share our experiences with you today. And so with that, here's a brief overview of what we'll be talking about. Paul will take you through what has happened since the first lockdown in Europe, which occurred in Italy exactly 1 year ago, or maybe one day out. He will also outline the pros and, in our opinion, limited cons of video conference hearings. And then after that, Steve and Chris will come in to discuss the main event, which will be the case that has led to this referral to the enlarged board and its potential consequences, both short-term and long-term, for patentees and opponents alike. So with that, I will hand you over to Paul.
Thanks, Robin. I'm sure you're all here for the main event, so I'll try and keep this bit not too long, but we thought it would help if we spent a little time going over the sort of timeline of what's happened with inter-party video conference proceedings over the last year. And as Robin says, going over some of the pros and limited cons of those types of proceedings. So, as Robin said, amazingly, the first lockdown in Europe and Italy was almost exactly a year ago, on the 8th of March, 2020. And pretty much from then, hearings before the EPO began to be postponed. By the time we got to the 1st of April, the EPO had moved all examining division oral proceedings to video conference. For those not aware, it was already possible to hold examining division proceedings by video conference, and had been for a very long time. And so we, in particular, Steve and Chris, with the clients they work with, very much came to that with a lot of experience. Things were moving fast, and on the 14th of April, the EPO kicked off a pilot project for inter-parties, so opposition proceedings, first instance proceedings, to be held by video conference. I think initially this was only for cases where translations were not required, but the EPO moved quite quickly to get that technology up and running as well. From my personal point of view, in hearings that I had during that time, it ran very smoothly. It was like a normal sort of ex parties examining proceedings by video conference, but there just so happened to be another party there. It ran very well. Although it was definitely clear that some attorneys, perhaps those based more locally to the EPO offices, were less used to video conference proceedings. Also during that time, some Board of Appeal hearings were being held by video conference, although they've not yet arranged the technology to enable translations. And I think, again, they actually started with examining division appeals as opposed to inter-party proceedings. And I had one of those exam division hearings before the Boards of Appeal, and again, it ran very smoothly, even though the 3 board members of the Board of Appeal were in different rooms. But I think they were all in the EPO buildings, but just separated physically. By the end of autumn, to provide clarity to parties, the EPO announced that all opposition oral proceedings would be held by video conference until the 15th of September this year, 2021. And then the Board of Appeal made a proposal to change their rules of procedure to specifically enable them to hold video conference proceedings without the consent of the parties. And these new rules are due to come into effect on the 1st of April. There was a brief period for consultation, and now those rules will be coming in. However, on the 1st of January this year, the board started to conduct video conference proceedings without agreement from all parties. And at the same time, they'd implemented the technology to enable translations. And again, I had the opportunity to have one of those proceedings in early January with translators. And again, it worked very well. It was very slick. The translations were as excellent as ever. The technology worked flawlessly. Went very well. And then on the 8th of February, Steve and Chris had their opposition appeal hearing, which resulted in the referral to the Enlarged Board. And we'll get to the details of that very shortly. So that was the timeline. But before we do get to Steve and Chris's case, what were the impacts of the lockdowns and resulting postponements? Well, we see here that actually I think the boards did quite well, with only a third less hearings in 2020 as compared to 2019, with about a fifth of those hearings held by video conference. And what we see is that the outcome from opposition appeals remained roughly the 5-year average of, what are we looking at there, sort of 42-43% win for the opponent. And where we say win here, we mean the patent was revoked, but of course, an amended patent might also be a win for the opponent, depending on how it was amended. So finally, for me, what are the pros and cons of video conference proceedings? Well, they're certainly easier and cheaper for the parties to attend, and that definitely results in an environmental benefit, less flights into Munich. It also enables clients from outside of Europe to attend at very much lower costs. They can simply dial in. I had a client from Japan dial into proceedings, and it worked very well. Admittedly, it was fairly late in their day, but nevertheless, they were able to attend without having to spend a few days on a plane. We've also seen good case management, very punctual restarts, no more waiting outside the hearing room for an indefinite amount of time. Very much increased the efficiency of attending proceedings. It's also easier to share documents via a dedicated email address that each of the parties gets given before the hearing. So those last-minute auxiliary requests, if you need to file them, can now be filed instantly, electronically, easily readable to all parties, with no one having to run off and finding a photocopier that hopefully works for you. And we actually think that we might see a faster time to hearing There are many more rooms at the EPO capable of holding video conference proceedings than there are capable of holding in-person hearings. And so hopefully some of the backlog can be reduced as a result. And so the link to the first point I made, it's also easier to access as a third party. Inter-parties proceedings are open to the public at the EPO, and all third parties, all the public needs to do now is request the link to go in and view the oral proceedings. And indeed, one of the first opposition video conference proceedings I had last year, which was, I think, fairly on in the process, there were a lot of public in attendance, presumably lots of other attorneys signing in to see how it all works. And then finally, the cons. And as Robin said, we actually don't really think there are too many cons at all. We've seen no major issues. The lack of physical personal interaction requires a little getting used to. But again, our experience of examining divisional proceedings by video conference, I think, really helped us there. And without that physical interaction, it can be more difficult to read the mood of the board, especially when they're in different rooms. So you can't actually tell whether they're interacting with their colleagues, sort of giving them looks to say, oh, that seems to be a good point, note that down. But actually, in practice, we should be focusing on our arguments anyway, making them as straightforward, as simple as possible, and as powerful as possible. So we don't really see that as a particular problem. I think the biggest con, and we'll get to this in a little more detail later on, talking about this particular case, but the inability, or at least difficulty, in demonstrating physical examples, and to a lesser extent, but still important, the difficulty in explaining difficult concepts without whiteboards, without a board to write on and show the board and the other side what you're thinking. But in reality, this happens quite infrequently. So it doesn't seem to be a major issue. And I think finally, from the cons, there's definitely an extra level of complexity when translators are required. But again, in practice, it works very well. The technology is easily up to the required standard to enable translators. The volume of the original language gets automatically turned down for whoever's listening in a different language, and turns back up again when the translations are no longer required. It works very smoothly. Not on the slides, but from a personal point of view, a definite con is I definitely miss the sort of celebratory beers in the beer garden afterwards, though, especially when we've got colleagues in Munich that we don't get to see so much these days. But that's a personal point of view and nothing to do with the case handling. So I shall stop there and turn you over to the main event, as it were. And I think Steve is going to take it from here. So, Steve.
Yeah, thank you, Paul. Thank you, Robin. I'm just having a quick check. There are no questions in the chat, so obviously covered everything extremely well there, Paul. For my section here, if you have got any questions, please do put them in the chat and we can answer them at the end. Okay, so I'm going to talk about the recent referral that was made in the case that Chris and I were handling. What I should point out is at the moment this case has not actually been referred. There is a decision to refer it, but the referral has not actually been made at the moment. And as I'll come on to later, there is a slight question following a submission that was filed yesterday as to whether the referral is actually going to go ahead. But what we can do for now is talk about the case, talk about the background, and see what we are expecting to happen. So we're talking about a referral to the Enlarged Board of Appeal. For those of you who are not familiar with the Enlarged Board of Appeal, this is not another instance for appealing a particular case. So it's not the case that you would have an opposition and then go to appeal and then have a further appeal to the Enlarged Board of Appeal. Instead, the Enlarged Board of Appeal is there to decide upon points of law which are considered to be of fundamental importance. And in general, the questions that go to the Enlarged Board of Appeal are being referred to them by a Board of Appeal or indeed by the President of the EPO. So the sorts of cases that go to the Enlarged Board of Appeal may be where there are two or more cases which have interpreted a point of the European Patent Convention differently, and therefore the Enlarged Board of Appeal are being asked to clarify what is the correct interpretation. Now, referrals to the Enlarged Board of Appeal do not happen very often. We've had about 40 years since the European Patent Convention came in. In that time, there's been about 120, 130 referrals that have been made to the Enlarged Board of Appeal. So that's sort of 3 or 4 a year, something like that. So as you can imagine, we're all quite excited that we're involved in a case which is going to the Enlarged Board of Appeal because it's quite a rarity. Now, the other excitement I have is talking about the detail of the case, but I have been asked specifically by Robin not to go into too much detail about the case, partly because we don't want to bore everybody, and partly because Chris wants an audience for his part of the discussion later. So suffice to say that this was a case in the electronic fields, but I don't think that's actually going to matter for the referral. I think this is equally applicable to any area of technology, whether you're life sciences, mechanical, electronic. The questions are still going to be relevant. I appreciate that different parts of the industry may have slightly different views on the appropriateness of oral proceedings by video conference, but in general, the question is going to be the same. The one thing that I will just mention is that this case was one which was perhaps a little more complex than other cases I've handled. By no means the most complex, but there was a level of complexity that was in the claims and therefore was going to be in the discussions, and that might have an influence on the suitability of video oral proceedings. Okay, next I've got a timeline across here, a timeline of what actually happened. The one thing that's not on my timeline is when the case was first filed. It was first filed back in 2004. And that's interesting because that means the patent will expire in 2024, in 3 years' time. So timing here is a bit of the essence, because if we're not careful, we won't get final decisions until after the patent has expired, which is never a good situation to be in. But this case granted in 2010. Opposition was filed within the normal 9-month opposition term. Normal opposition with a few rounds of correspondence through to oral proceedings that were held in person at the EPO in Munich in 2015. And I'm very pleased to say that at the oral proceedings before the opposition division, we won. The case was maintained on the basis of our main request. The original opponent filed an appeal, so they became the appellant. I'll probably use those terms, opponent and appellant, interchangeably through the rest of this talk, but the appeal was filed in 2015. And again, a few rounds of correspondence took us to January last year, January 2020, when we received the summons to attend oral proceedings. The summons setting the oral proceedings to be held in May of last year at the EPO in the Howe, just outside Munich, to be held in person. Now, I don't need to tell anybody here that quite a lot happened between January 2020 and May 2020. And so as we got closer to the oral proceedings, Chris and I became clear to us that we were not going to be able to travel to Germany to attend the oral proceedings in person. And indeed, right through to the middle of May, the EPO weren't actually holding oral proceedings before the boards of appeal in person at all. And so we wrote to the office and asked for the hearing to be rescheduled. As Robbie mentioned earlier, Chris and I have got a lot of experience of video oral proceedings, in particular before the exam division. So we did consider whether it would be appropriate to have these oral proceedings by video conference. We decided that it wouldn't, mainly for the simultaneous translation issue that Paul was talking about earlier. We were going to be talking in English. The appellant's representatives were going to be talking in German, and therefore there was a need for simultaneous translation. At the time, the EPO were largely using Skype for Business as their platform, and that wouldn't have allowed, as far as we were aware, for simultaneous translation. And so for that reason, we decided that we didn't think video oral proceedings was appropriate. And evidently the board agreed, because they rescheduled the oral proceedings for February of this year, again to be held in person at the EPO in the Howe, clearly when the COVID pandemic would all be over and we'd all be travelling everywhere again. Well, as we know, that didn't happen. And so at the start of January, we again wrote to the EPO advising that we weren't going to be allowed to travel to Munich to attend the hearing in person, and therefore asking for the hearing to be rescheduled again. Now, by this time, start of January, the EPO had been having oral proceedings before the boards of appeal by video conference. They were able to do simultaneous translation. And as Paul mentioned earlier, whilst the new rule hasn't come into place saying that the oral proceedings could be held by video conference without the consent of the parties, the EPO were changing their practice so that they weren't requiring consent. I must say what I had expected was that I would get a letter asking for our consent to have the hearing by video, but we didn't actually receive that. All we actually received was a notice rescheduling the oral proceedings to be held by video on the same date and asking for our details to dial in to the call. So no consent requested, therefore no consent given, but the oral proceedings were going to continue by video on the 8th of February. So what actually happened at the hearing itself? Well, we were asked, as were the other side, to turn up half an hour or so before the hearing was scheduled to start, which we all dutifully did, dialing in on Zoom as you are doing now into this call. Everyone turned up. Chris and I were sitting at our own homes. Each of the members of the Board of Appeal were sitting in different rooms. The representatives for the appellant were sitting in their conference room. The chairman went through all of the discussions about how the oral proceedings were going to be held, gave us the email details for sending any late submissions, told us what was going to happen if we lost connectivity at any time. We went through and tried the simultaneous translation, which, as Paul mentioned, seemed to work very well. Only issue that we sort of noted, and something which apparently is quite common in these proceedings, is that you have to wait a little bit after the simultaneous translation has ended before the next speaker's microphone picks up. So if you're doing any of these oral proceedings, make sure that you have a bit of a delay to allow for your microphone to pick up. But that was something that we could easily deal with. Checked our identity, went into breakout rooms so that we could check who everybody was. And then we began the formal part of the oral proceedings. As always, the chairman's first question was whether the parties maintained all of their requests. When it came to the appellant, their main request was that our patent be revoked in its entirety. But at this point, they raised the question of a possible referral to the Enlarged Board of Appeal of the question of whether it was legitimate to hold oral proceedings by video conference without the consent of the parties. And this clearly gave the board something to think about. This was a request that perhaps they hadn't necessarily been expecting. We certainly hadn't been expecting this. And so the first thing that the board said was, well, if you actually want to make this as a request, you need to file it in writing. And so the representatives of the appellant sat there on their mobile device, typing in the request, a question that you can see there on the screen. Can oral proceedings, according to Article 116 EPC, be replaced by a video conference if the parties do not agree? There was some discussion as to how this question was going to, or how this request was going to be asked, be presented. And the appellant suggested that this should be presented as an auxiliary request. Now, this caused us some concern, because what they were actually asking was that for their main request, they wanted the patent to be revoked in its entirety. And if they were successful in that main request, then we'd never get to move to the auxiliary request. So the patent would have been revoked on that basis. However, by putting it in as an auxiliary request, it was saying that if they lost their main request, so in other words, if the patent was maintained, then as an auxiliary request, they wanted a referral to be made to the Enlarged Board of Appeal to ask whether the oral proceedings were legitimate. And the expectation clearly would be that if the Enlarged Board of Appeal said no, that we would have had to have had a retrial effectively of the main oral proceedings. So our concern at this point was that the appellant was effectively asking for two bites at the cherry, two attempts to win the case. So at that point, we suggested that whilst we weren't pushing for a referral to be made to the Enlarged Board of Appeal, that if an auxiliary request was going to be admitted from the from the appellant to make a referral if they lost, then we would also want to consider being allowed to make a similar auxiliary request if we lost. So at this point, the board went away and had a thought and came back, to my mind, quite clearly with the view that what they needed to do was stop the current appeal proceedings to make a referral to the Enlarged Board. But when they came back, they did want to have some discussion about some of the possible reasons why it was felt that video oral proceedings were inappropriate. And this goes back a lot to some of Paul's cons that he was talking about earlier. I'm not going to try and go into all of the points because I don't think that they were really determinative in whether the referral was going to be made, but it gives a good indication of the sort of thought process. The main issue was whether having oral proceedings by video conference gave a right to be heard, and in particular, whether it gave a right to be heard properly. And this was some of the justification for the request being made as an auxiliary request. The opponent's view was, well, if they went through the hearing and they were successful, the patent was revoked as they had requested, then clearly they had been heard and had been heard properly. On the other hand, if we went through the hearing and they lost and the patent was maintained, then that could well have been because they hadn't been heard or hadn't been heard properly. So that's why they felt it was appropriate to have it in as an auxiliary request. The complexity of the discussions was something that was mentioned. And in particular, was there a need for a whiteboard, or was there going to be able to use a whiteboard? If it was in person, they would be able to. By video, they weren't. And indeed, thinking back to the oral proceedings before the opposition division, I do recall that extensive use was made by the opponent's representatives of the whiteboard that was in the room at the time. Have to say, I think that these days, with more and more of us getting used to video conferencing, there are other alternatives to whiteboards. You can actually have screens sharing your computer screen, much as we're doing here. We're sharing a PowerPoint presentation with a lot of the information on. I think PowerPoint can equally be used in oral proceedings if necessary to avoid the need for a whiteboard. There was also the question of judging the facial expressions, the mannerisms of the other people present at the hearing, and how it wasn't very easy to do so when everyone appeared in a small little screen on the right hand side of your monitor. I have to say, I don't necessarily find it that easy to judge all of the expressions when you're in the room, especially when the representatives for the other side are sitting over beside you. And so the best you can see is a side profile of the one closest to you. I find it much easier to judge expression when you can see the full frontal view of the face of the representatives. But I think these are things that it's just a matter of adaptation to a large extent. Another point that was mentioned, and I haven't gone into this in any greater detail, so I don't know how accurate it is, But there was a point as to whether there is a national right to be heard in person. A reference was made to Germany, so if we've got anybody from Germany on the call, they might be able to give us some information in the chat on this. But there was a suggestion that in Germany, there is effectively a constitutional right to be heard in person. And therefore, if the EPO were going to have hearings by video, you lost that right. So anyway, that I guess takes us to the conclusion of the hearing, where the board decided that they were going to stop the hearing at that point. They weren't going to hear the substance of the hearing, and instead were going to make a referral to the Enlarged Board of Appeal with questions that were to be determined in due course. Now, I'm going to come on in a minute to discuss what the possible questions would be. But one other thing I did want to point out was that there is another route that could be taken to get to the Enlarged Board of Appeal. And it's one that in this case may actually have been perhaps more suitable for the appellant. And that's a petition for a review. Now, a petition for review is available to a party who is adversely affected by a decision of the Board of Appeal, essentially where there has been a procedural violation, such as a violation of the right to be heard. And the way that this would work is that if somebody during a procedure felt that they had been adversely affected by such a breach of procedure, they could then apply to the Enlarged Board of Appeal for that to be reviewed. And if they were successful in that application for review, then obviously we'd go back to and retry the original case. So largely what the appellant appeared to be trying to achieve here, but with the actual benefit of having heard the case in full to start with. Now, there haven't been that many petitions for review, and I have to say, looking through them, most of them have been rejected. Many of them seem to have been rejected for a formal reason rather than a substantive reason. So it might not have been the ideal approach, but nevertheless, it would have been a different approach that could have been taken. I haven't been able to find any petitions for review that have been on the specific question of whether it's legitimate, whether it's legal to have oral proceedings by video conference, though, of course, there's a pretty limited time period in which those could have been filed. Whilst, as Paul said, the EPO have been having or could have had video oral proceedings without consent since the 1st of January, the EPO was actually closed for a long Christmas and New Year break and didn't actually reopen till I think it was the 10th or the 11th of January. Our hearing was on the 8th of February, so it's a fairly small window. So it's not surprising that there's been no petitions for review on video oral proceedings. There is one petition for review, which is due to be heard at the end of this month on oral proceedings in COVID times, if we can call it that. And that's a case where actually in many ways video oral proceedings would have, I think, avoided the problem that the patentee is complaining about. Because in this case, the oral proceedings were held in person at the EPO, but the inventor, who was based in Denmark, I think, was unable to travel to the EPO. And the patentee argued that if the inventor had been there, had been present, they would have stood a much better chance of succeeding. And so they have said that a breach of procedure occurred because they were not able to be properly heard because the inventor couldn't be there in person. And of course, if the hearing had all been by video conferencing, then the inventor could have been there. I think looking at the papers, this case is actually likely to be decided again on a formal issue, whether the procedural violation was properly raised during the proceedings rather than on the substance, but it's a case that we will have a look at with interest. And one of the reasons why I say this petition for review may have been a more appropriate action that the appellant could have taken in this case is the development that Robin mentioned that happened yesterday, which is the appellant in our case actually wrote to the EPO to withdraw their auxiliary request. So to withdraw the request for a referral to the Enlarged Board of Appeal, so that I presume they were hoping that the main substance of the case could be heard more quickly. Now, it's interesting as to what's actually going to happen following the withdrawal of the auxiliary request. My personal view is that there's still going to be a referral to the Enlarged Board of Appeal. There's been lots of interest. You've got all of you joining us today who are obviously interested in this. That's been reflected around Europe and indeed by various of the patent institutions around Europe. So I think very much that as Robin put it earlier, the genie is out of the bag. And so I think everyone knows about this potential referral. I think it's going to be quite hard for it not to now be referred to the Enlarged Board. But we'll watch this space. So the last thing that I'm going to talk about for watching this space is the questions that are going to be referred to the Enlarged Board of Appeal. Again, a little bit of background. The way that questions are typically structured when they are referred to the Enlarged Board of Appeal is that there's typically a fairly broad question that's asked as the main question, and then a number of supplementary questions which are conditional on the answer to the first question. So trying to think what's the broadest sort of questions that can be asked. Well, we've got one here. Can oral proceedings be held by video conference? In other words, is there a legal right to be heard in person? If that's the broadest question, the next question coming down, I'm sure, will be whether there's a need for all parties to consent to the oral proceedings being held by video conference. And indeed, that might be the broadest question. That might be the main question. I guess supplementary questions are whether, if a party is not giving consent, whether they need to give reasons why they're not going to give consent. And if so, what sort of reasons would be acceptable? Does it need to be based on the complexity of the subject matter? We've talked all through this discussion about oral proceedings that are held before the boards of appeal. It's possible that this could not just apply to the boards of appeal, but could also apply to examining division and opposition oral proceedings. Or it may be that the question is whether there should be a difference between whether video oral proceedings are appropriate for inter-parties proceedings, so where there's an opponent and a patentee, or an appellant and a respondent, or whether it could also apply to ex-party proceedings where it's just the party talking to and arguing against the EPO. So do watch this space. We will try to make sure that we send you details as soon as we know what the actual questions are that are being referred to the Enlarged Board of Appeal. And it's got some very much long-term interest because it's going to determine whether and how we continue to have video oral proceedings, at least before the boards of appeal. But probably of more concern is what's happening in the short term. What's happening before we actually get the questions set out and structured, and what's going to happen before we get the decision of the Enlarged Board of Appeal? What are the short and medium-term consequences? And I'm going to hand over to Chris to talk us through that. Over to you, Chris.
Thanks, Steve. I'm going to talk briefly about the consequences of this referral in the short term. And this is regardless of the exact details of the questions to be referred, and also regardless of whatever decision the enlarged board comes to. The most important effect in the short term is on pending appeal cases for which parties have been summoned to oral proceedings by video conference. And this is because any party to an appeal that has been summoned to oral proceedings by video conference and who objects to the use of the video conference technology could be able to use this referral to get a postponement of the oral proceedings for their case. Now, this could be decided by each Board of Appeal on a case-by-case basis if a party objects. And in fact, we have heard this is already happening, even though the questions of the referral haven't been published. Or the Boards of Appeal could collectively announce that they will postpone any oral proceedings by video conference to which a party objects, maybe if there's a tipping point of individual requests for postponement, or the nuclear option perhaps, the Boards of Appeal could collectively announce that all oral proceedings are postponed. I think this is probably unlikely, For one thing, some parties are happy to have things heard by video conference. But if the boards of appeal are particularly cautious and worried about a negative decision from the enlarged board, then it is a possibility, albeit an unlikely one. Can I get the next slide, please, Paul? So the next thing to note is that not everybody would welcome a postponement. We have a graph here on the right that shows the outcomes of the opposition appeals from the perspective of an opponent. And similar to what Paul said earlier, the opponent's success rate here is 42%, meaning that on appeal from the opposition division, 42% of patents are revoked. Now, this is actually higher than the opposition division, which revokes in merely 27% of cases. Also, even cases that are maintained on appeal are more likely to end up with narrower claims. So what this means is that the final decision of an opposition appeal is going to be bad news for the patentee in many cases. But until that final decision comes, the patent is still in force. This means that patentees who are worried about losing on appeal might tactically object to having oral proceedings by video conference, regardless of their actual opinion on the use of the video conference. They might do it just to postpone a negative decision. And this is bad news for third parties because the patent is still in force until that decision comes. And third parties could be at risk of an injunction, even if the patent will eventually be revoked on appeal. Now, while damages can be awarded for a preliminary injunction obtained on a patent that is later found to be invalid, these damages are often not enough to compensate the third parties for their lost opportunity to enter the market. Can I get the next slide, Paul? So, as I said just a minute ago, there have already been a few appeal hearings that have been postponed as a result of this referral. And these postponements are likely to last until either in-person hearings become possible again, or the enlarged board issues a decision that supports video conference or proceedings without the consent of the parties. Now, if in-person hearings are possible again, then parties can attend them in person at the EPO, which is obvious, I suppose, but this will happen even if we're still waiting to hear back from the enlarged board. If the enlarged board acts quick, by which I mean they issue a decision before in-person oral proceedings become possible again, and the enlarged board decides in favour of video conference oral proceedings without the consent of parties, then oral proceedings by video conference are back on. Otherwise, we're waiting until the in-person hearings become possible again. Can I get the next slide, Paul? So this, of course, begs the question, when will in-person oral proceedings become possible again? And put simply, we don't know. But it depends on the COVID situation in Munich, where the oral proceedings would need to be held. And it also depends on the COVID situation in the various EPO member states where applicants and representatives are based. So we don't know, but I would be surprised if the EPO resumed in-person oral proceedings before the summer, even if the COVID situation improves across Europe. And if we recall the announcement last year that in-person oral proceedings were suspended until September of 2021, that date is probably still going to apply, at least as an earliest date. Can I get the next slide again, Paul? So if we assume that in-person oral proceedings won't be possible before the summer at the earliest, might we get a decision from the Enlarged Board of Appeal before then? Well, the fastest Enlarged Board decision in recent years seems to be G2 of 19. Now, This is the case where the enlarged board considered whether oral proceedings can be held in the Howe building on the outskirts of Munich city proper if a party objects. And the decision on that case came about 6 months after the original appeal hearing before the technical boards of appeal. So if the enlarged board follows this timescale, then a decision could come by August. But of course, there will still need to be a few months for any postponed oral proceedings to be reappointed. So we could be looking at maybe November oral proceedings. And that's, of course, if the Enlarged Board of Appeal decides in favour of video conference oral proceedings without consent. And also, if the technical boards of appeal have time, we have to remember cases being postponed in the meantime will increase the backlog of cases that are waiting to be decided. And these cases will need to be rescheduled around any other appeal hearings already scheduled for November onwards. So there's no guarantee of oral proceedings being reappointed immediately. It is possible that the Enlarged Board of Appeal will act quicker, given the urgency of this issue for all of us who use the EPO. But the questions haven't yet been published, and the Enlarged Board can't do anything until then. And even then, there will need to be time for the Enlarged Board to summon the parties, including us, to oral proceedings. The questions might come any day now, but there will still be a couple of months before oral proceedings. And that's ignoring the question of whether the Enlarged Board will appoint oral proceedings by video conference or decide to do it in person. So this means that anyone who wants oral proceedings to take place as soon as possible, such as a third party waiting for a patent to be revoked on appeal before they launch a new product, is relying on either countries across Europe, not just Germany, getting the COVID situation under control quickly, or the Enlarged Board acting quickly and issuing a decision in favour of video conference oral proceedings without consent. So in each case, there is a risk that it doesn't happen quickly. There's a risk that at least some of the European countries don't get COVID under control. And there is a risk that the Enlarged Board doesn't act quickly, as we see in nearly every other Enlarged Board referral. So this means it could be some time before any postponed oral proceedings actually take place again. So I'm sorry to be the bearer of bad news to anyone who wants a final decision on their appeal case to come quickly. Although I do wonder if I may be a bearer of good news to anyone who wants to tactically delay a final decision as long as possible. All of this assumes that the referral to the Enlarged Board is going ahead. But in any case, the fact that the technical board, in our case, has made the decision during the oral proceedings to make a referral suggests that it likely is going to go ahead. And even if the referral doesn't proceed on this case, there will be other cases. I'm sure of it. Anyway, I'm going to pass you back to Robin.
Thanks very much, Chris. And thank you also, Steve and Paul, for the run through of both this recent referral and everything that's happened over the past year. Whilst we were prepping for this webinar, I certainly learned a lot. And the one I think important take home that Paul alluded to was the fact that there's no real evidence that ViCos are bad for the opponent or the patentee. After a year of having video conference hearings, both parties appear to have been getting similar results to what they've been getting in the previous 5 years. And we shouldn't forget that even moving forward, if all parties agree to have the hearing to be held by a video conference, then that hearing should still go ahead, aside from the nuclear option that Chris referred to. So we hope the video conference hearings will continue to move forward, because at the moment, they're the only way that we can have hearings before the EPO. So without them, we would be grinding to a halt. As Chris mentioned, there's going to be uncertainty for many months, and we'll do all we can to keep you in the loop. And of course, you have to be aware that if you are one of the parties that is in wishing to have a appeal hearing quickly, there is always the risk that the other side may not consent, and as a result, the hearing may well have to be postponed until the factors that Chris just mentioned have been resolved. And the other thing that will be interesting over the coming months is whether we'll see a rise in petitions for review where parties feel that their right to be heard has not been met. Maybe looking a bit more into the future, from discussions with employees at the EPO, with examiners, and things that we have heard, we believe the European Patent Office is quite keen to use video conference proceedings in the future. I don't think they'll be replacing in-person hearings in the near future, and personally, I hope that doesn't happen. But it would be nice if they offer an alternative to parties, because they do have advantages, and they may well be a useful way of managing the backlog of hearings that are clearly building up in light of the COVID pandemic. So if you're going to be involved in oral proceedings in the future, and you have an option to either do them in person or attend them in person, or to attend them via video conference, there is certainly a few things to consider. And it may be that, for example, a video conference hearing will be scheduled much faster. A number of the cases that I'm involved on have got more than 10 opponents involved. And when you have cases like that, one of the biggest problems is finding a room to fit everybody in. And that will often lead to huge delays in the hearing being heard. So if situations like that can be resolved by all parties agreeing to video conferencing, that would be a huge benefit. Equally, if you are unable to attend, you're unable to travel, or cost or environmental concerns mean that you'd rather not travel than to Munich, then a video conference hearing is always a good way to manage that. There isn't, for example, cross-examination of witnesses at EPO, opposition and Board of Appeal hearings. Obviously, witnesses can be heard, but that can be done via Zoom if it's all managed correctly and everybody's ready and prepared to work within that virtual environment. And so really the only need in the future to have an in-person hearing is if there is a need to present physical evidence, as Steve mentioned. And Paul touched on it right at the very beginning. The other nice to have of attending oral proceedings in person is that it's always nice to be able to head to the beer garden afterwards to either discuss your success or potentially drown your sorrows. So I hope that what the future will be a hybrid of either all in-person proceedings or all video conference proceedings. As an interesting add-on at the very end, some of you may have already seen that yesterday the EPI, so the representative body for European patent attorneys, actually filed third-party observations on this case, in which they submitted some of their own potential questions to be referred to the enlarged board. And in those questions, they implied that they wouldn't necessarily have a problem with mixed hearings, with some people present in person and some people dialing in via video conference. Now, this is something that I personally would struggle with. I hope that's not something for the future. But it would be worth, or I recommend having a read of this letter from EPI, because then it gives you an idea of how people are approaching this referral and what they potentially see as solutions for the future. So there's a lot of open questions on this case. And with that, we will move to questions on this seminar